on insider trading regulation, and based on the queries received during those webinars, SEBI released FAQ. Thanks to Sri Sundarshan sir for his proactive approach. Friends, contra trade is yet another area under PIT regulation where there still remains some unanswered questions on which there is no consensus amongst the compliance officers. Why we decided to choose this topic of contra trade for this discussion and today's webinar? Because we want to understand that how the compliance officers are thinking and what are their issues and what is the logic behind this, the regulator can explain to us. As you know, in a listed entity, designated person DP and their intermediary relatives cannot execute contra trade or opposite transaction for the next 6 months or such longer period as may be specified in Code of Conduct. Compliance officer may, however, grant relaxation for strict compliance of contra trade restriction subject to the condition that is not against the provision of SEBI PIT regulation. Now, here is the catch. Now, the compliance officer, we are saying he can do, he can tell, but the question is the compliance officer is also sometimes confused and they are giving different interpretation. So we should understand that why it is happening and how we can make it a system or this law in such a manner that everybody thinks alike. That's why the regulator will explain to us the logic and we will tell them the problem of the compliance officer. Where a contra trade has been executed inadvertently or otherwise in violation of restriction, the profits from such trade are liable to be disgorged by credit to the investor protection and the education fund set up by SEBI. Now, this is also which profit, how to calculate the profit, how to deposit it, how the compliance officer will do. All these issues we'll discuss today, and we'll discuss the quantum also. The objective of the webinar is to discuss threadware the subtitle implication of contra trade restriction and the relaxation which can be granted there under and try to arrive at a consensus on questions which have remained unanswered. We will also discuss informal guidelines and FAQ issued by SEBI from time to time. Senior SEBI officials as well as the veteran corporate profession have very kindly agreed to address the participant and answer their queries. Today, Narayan Shankar and Savitri, they are from the corporate world. They are the compliance officer also. And Mohini, she is looking after and discussing with various corporate. So we will get feedback from them. And then we have a two learned regulator, Mr. Sundarshan sir, and along with Mr. Naveen, they will tell us the logic behind. So today, after the webinar, I hope that contra trade related all issues will be solved. So we have eminent speaker for today's webinar. First, Mr. V.S. Sundarshan. He is a chief guest, is executive director in SEBI. Prior to his work, working as a chief general manager in inquiries and adjudication department in SEBI. He has more than 32-year experience in development, regulation, and protection of interests of investors in Indian securities market and has worked in various departments of SEBI. He has supervised more than 500 investigation cases on market manipulation, insider trading, takeover, public issue, collective investment, compliance, and continuous listing. He strongly believes in sharing knowledge and has delivered more than 350 lectures within India and 25 lectures, more than 25 lectures in our overseas seminar on various topics related to the securities market. Thank you, sir. And your proactive approach is solving this complicated law in a very smooth manner. And I hope that all my other learned speaker will also agree that he's the person who is very open and always ready to accept the ideas. And he's always ready that whatever problem corporates are facing, it should be clarified, not with the just answer, but by giving a logic. You should have all clarity in future also. So welcome Sundarshan sir. He's just joining. He's chairing a meeting. So after that he will join. Then we have Mr. Naveen Gupta. He's Assistant General Manager in Surveillance Department of SEBI, handling the policy-related aspects. He has more than 14 years of experience in various areas like corporate bond market, portfolio manager, alternative investment fund, real estate investment trust, infrastructure investment trust, investment advisor, and such analyst. I welcome Naveen for this program. You are coming first time to our program. We always discuss issues and then question answer. So today we will definitely get advantage of your knowledge and vast experience on this particular subject. So welcome, Naveen.
Thank you, Mr. Vijay. Thank you for inviting me.
Then we have Mr. Narayan Shankar. He's the Vice President and Company Secretary in Mahindra & Mahindra. He has the experience of more than 2 decades in secretarial compliance and listed entity. And he is one of the pioneer and expert in this particular area. He is a company secretary, but he knows so many things. He was a member of the ESOP committee also formed by SEBI. And he is a member of Secretarial Standard Board of Institute of Company Secretaries. Welcome, Narayan Shankar, for this.
Thank you. Thank you.
Then we have Ms. Savitri Parikh. She's joining just now. She has over 28 years experience in company secretary and compliance officer, Reliance Industry. She has worked in various sectors, and she is a specialist editor of Ramaiya Guide of Companies Act and general editor of MC Bhandari Guide to Company Law. I welcome Savitri in her absence. She'll join shortly. Then we have Ms. Moini Vashne. She's a partner head ESOP and Insider Law Service professional. She was instrumental in developing CP-based application of ESOP Guardian to manage ESOP and Insider lists to comply with SEBI prohibition of insider trading regulation, which are running successfully in more than 100 companies. And Moni is interacting with so many companies related to various aspects of compliance on this thing. So now the program structure will be like this. First, I'll request Mohini to give her presentation on the topic, and then I will take the view from Naveen Gupta on this particular concept, how this has originated. Friends, you will agree with me, telling the answer is not a solution, but telling the root cause is always the future answer. Sometimes you are confused and you know the root cause, you know the understanding of SEBI that why they want to do this. And if you are clear this, then we can better understand in all situations, we can identify our own answer. And I think Sundaresan sir is always telling us that why they have brought out this law. Not he's giving direct answer, but telling the why they have brought out and then answer. So we will get answer from the Naveen from SEBI point of view that why this contra trade. So after this, we will have a question answer. So we have received more than 40 questions on this, and the public, those who are participating here, they can write their question, and we will ask the questions from our dignitaries, and after that, we will take the concluding remark from Sundaresan sir and other speakers. So over to you, Mohini. Just give the contra trade issue, that what are the problems, and give us the overview of the contra trade also. Then I will request Naveen to tell us the logic behind the contra trade. Over to you.
Yeah, good afternoon, everyone. I'm just sharing my screen.
Yeah, you can share. Yeah.
Yeah, it's visible, Moini. Go ahead.
So good afternoon, everyone. So today topic is contra trade. So contra trade in the SEBI regulations, if we talk about with respect to the insider trading, there it's a concept in the code of conduct of any company that the designated persons can't enter into contra trade. Definitely, it's a very small one paragraph only in the entire regulations in the code where it has been given as a contra trade. But the implications of contra trade and the applicability of it, definitely it's very wide. So if we talk about that, when this contra trade provision introduced in the SEBI insider regulations. So this contra trade provisions earlier not there in the earlier PIT regulations, that means insider trading regulations. But after NKSOD committee, it was introduced in 2015 when the regulations get overall amended. So the contra provision was first introduced in 2015. Earlier, there was no provision for the contra trade restrictions. After its introduction in 2015, there are many amendments in this, like in the amendment in 2019, if we go about. So there like the ESOP exercise and various other exemptions being introduced in this. Then in 2021, when the SEBI released its FAQs, or comprehensive FAQs, we can say, there also the contra trade provisions got a very good inclusion in that particular list of FAQs, wherein many earlier confusions have been removed through that FAQs. Then time to time, after its introduction in 2015, SEBI has also given the informal guidances on the contra trade provisions as well. So the contra trade provisions still, now we can say that how this a small paragraph in 2015, which was introduced, when it was introduced, then slowly the SEBI as well as the companies are also working on this and are taking guidance from the SEBI on this contra provision. When we talk about any contra provision, first we need to understand that in the insider trading regulations, what is acquisition of shares and what is the disposal of shares. So acquisition means any purchase from open market. That means if the securities are being purchased at the stock exchanges, even it's a simply transfer, not through stock exchanges, it will be treated as a purchase only. Then the shares acquired through non-open market transactions. Non-open means where the open market is not there, but definitely the people are getting the shares, like through bonus, shares, split, rights issue, FPO, open OFS, offer for sale, if there is coming. So in this also, the people, the designated person and the employees are getting the shares. Shares received as a gift, it is also an acquisition. Although we are not paying and receiving any money in this, but shares received as a gift is also an acquisition. Revocation of securities, when in case of it's a pledge, then it will be that it's treated as it's coming back. Exercising of ESOP shares, again, we are acquiring it. Then these are the types of acquisition. Any kind of other kind of subscription or acquisition by any other mode, it also falls in the acquisition. So even you are agreeing to subscribe, you are agreeing to purchase the shares, that is also falling under the ambit of acquisition. When we talk about the disposal, so disposal means sale of securities, similarly in the open market, off market, whatever means are there. Tendering of shares in the exit offer, buyback, all these are also a part of disposal only. You are gifting the shares to others, you are pledging your securities, even the securities are invoked after pledge. All these are also a disposal only. So these are the acquisition and disposal. So now what the contra says about? Contra says that there is a one tranche of acquisition and there is a one cases of disposal. So if once you have acquired, you can't sell, that means dispose. And once you have disposed, you can't acquire. So that means acquisition either way of, for example, if you have purchased shares from the open market or you have received the gift, but you can't dispose it off. Similarly, if you have disposed it off, you can't purchase or acquire it from any other means. So this is the restriction. That means restriction on taking any opposite position. So you can't do vice versa position in the as per the PIT code of conduct. Contra means you can't take opposite position, but there is a time gap, only we can say a cooling period which you need to maintain. You can take the opposite transaction, but a cooling period for the contra trade restriction is 6 months. So basically it's a minimum 6 months the law has mentioned, but in case if the code of conduct prescribes for any higher period, the code of conduct can prescribe. But basically if we talk about, so it's almost a minimum 6 months period within which you can't take any opposite position. So this is the a time period of the contra. So if we talk about that, there is a minimum 6 months gap. So if intraday, if any designated person is taking, then it falls under the contra trade. So intraday trade is completely prohibited for any designated person to indulge. With a simple example, we can understand this contra. For example, in June 2022, the person has acquired. Again in July, they are acquiring shares. Yes, they can do so because it's the same kind of position he is taking, same kind of trade he is taking, acquisition and acquisition. Now for a period of 6 months, he can't dispose it off. So if before in January, if he is trying to, he can't. But in case if he is going in February, he can, because 6 months cooling period he has to maintain between the acquisition and disposal. Now, contra means opposite. You can't do it for a 6 month. But who all people or who all category of the people are there who are bound by this contra provision? So the foundation of this contra provision is on the designated persons in the company and their immediate relatives. Because immediate relatives, we all know and we are all aware of that in the PIT, immediate relatives, which the designated persons declare that yes, he or she is my immediate relative, they are bound by, along with the designated person, to comply with the code of conduct and other regulations. So designated persons along with the immediate relative has to maintain this cooling period of 6 months before entering into any opposite position. Example, with a simple example, husband who is a designated person in a company, if acquiring shares of the company, so his immediate relative, whether he's spouse, he's children or a sibling, but he can't sell, even though they cannot sell off the securities for a minimum period of 6 months. So collectively, you have to check on this. For the ease of reference, who all are in the designated persons? The designated persons in the company are the promoter, CEO, and employees 2 levels below CEO, employees of material subsidiaries, any support staff such as IT or secretarial staff of the company, or any other person designated by the code. So that means the person who are generally be deemed to be in the possession of UPSI, that means unpublished price sensitive information, all time generally, they are being designated as the designated person. So they are bound and they have to follow this contra provisions before entering into any trade. But with respect to the other persons, like who are non-designated employees, that means who are not designated as per the insider trading code of conduct, they can trade, they can take the opposite position, but definitely the other regulations of the PIT are applicable on them, because if they are aware of any UPSI and they are indulging in that trade, then definitely contra is not there, but they have to follow and abide other regulations of insider trade. Yes, you can't go for the opposite position, but there are few exemptions which in the law itself it has given, that you can, yes, take the opposite position. That means if you have acquired, you can dispose, and you have disposed, you can acquire, but only the means which have been mentioned in the law that you can do. For example, exercising of ESOP shares, you can either the designated person can do. any plan, any trade, if they have mentioned in the trading plan, they can do. That means through trading plan, they can do. Trading plan means the trading plan in the PIT regulations being introduced for the people who are generally be in the all-time position of UPSI. And because of that, they're not being able to trade. So they can in advance can give the trading plan. And it is available in the public. So that's the reason why the trade executed as per trading plan are generally allowed that you can do so. Then if you're tendering the shares in buyback and exit offer, that is allowed, that this disposal is allowed. Then if the acquisition of the shares through bonus, split, merger, amalgamation, demerger, that is also allowed under the same, this against the contra. Then any acquisition through FPO, OFS and the rights issue, that is also allowed. So these are the acquisition and disposal, which is allowed even though you have acquired or disposed of your shares earlier. In case if the contra provisions are done, contractivities, contra trade is done, then any profit the person has earned is being disgorged by the company, and then the same amount is to be remitted to the credit to the SEBI for the in the IPF. So this is the consequence of this. Now, because contra is an opposite transaction, generally the compliance officer who is the entirely monitoring and entirely managing the insider trading regulations in the organization, in the listed entity, they are on a daily basis, day-to-day basis, they are getting these kind of challenges from the designated person. Like many of the times, the designated persons do intraday trading. 6 months calculations, they are not even able to calculate when the 6 months is going to over. The dilemma key, what is the opposite transaction? Then opposite transaction is on quantity basis or on a transaction base. Like that means they generally we think of it's on FIFO basis. Sell off by the portfolio managers. They say that they are not aware of, and their portfolio manager has undertaken that thing. And then many times the immediate relatives are with us or not. I have purchased, so I can't sell. My wife has purchased or sold off. So these are the challenges which generally the compliance officer is facing from the designated person. And I'm open to giving an open to Naveen. They can give us a brief and a guidance on this contra from the citizen.
Thank you, Moni. Thank you. That was indeed a very cogent explanation of the framework, the contra trade framework that SEBI has and how it has evolved and what shape it currently is in. I would like to extend a warm evening to my fellow panelists and all the other viewers who have joined the webinar from different parts of the country. I would also like to thank Mr. Vijay and the entire team at the Corporate Professional for organizing this webinar. This indeed is an important topic, and there are a lot of doubts, confusion, both among the designated persons and the compliance officers, and that reflects in the kind of queries that we receive, despite of we having issued the detailed FAQs in this respect. And Corporate Professional also, as Mr. Vijay said, has done a few webinars on the aspect of PIT. When we look at the PIT regulation, so as Mr. Vijay said, that to give a brief background, then why contra trade came to the picture, what exactly is it, why this concept came into the being. When we look at the PIT regulation, the name itself suggests prohibition of insider trading. That essentially means if you are in possession of UPSI, do not trade. That's the basic fundamental of the regulation. Now, contra trade, when we look at it, where does it get applicable? It's essentially applicable on the designated person and their immediate relatives, where the designated persons are those individuals which are designated, of course, by the listed entity only, but then who are reasonably expected to have price-sensitive information, whether UPSI or not, whether it's, but yeah, they usually have price-sensitive information. So the idea is that someone who has price-sensitive information, and that too on a very regular basis, should not indulge into such kind of trading activity, which is first speculative in nature. Second, also arises suspicion that why, if somebody has bought today and selling tomorrow, and also is privy to a lot of information which may not be generally available to public at large, is doing that. So I would rather say it's a prudent corporate governance requirement, which essentially and also the basis of the regulation that you should not be trading when in possession of a UPSI, which warrants for a contra trade kind of a provision. So that there is a policy in place where people who have this information day in, day out should not be trading frequently. Now, the issue of so the period of 6 months, that is something which has been enshrined in the regulation, which came into the being after a lot of discussion. The inputs were that the SODI committee also introduced the idea of contra trade. So after all of that, the 6 month period came into the being. But I must say here that this requirement of contra trade per se is not something which is like cast in stone. And that's why there is a via media provided in the regulation where the compliance officer can give an exemption after checking the bona fides of the transaction under question, and after checking that of course the transaction should not be in violation with the other provisions of the PIT regulation. So there are certain relaxations which can be provided by the compliance officers. Another aspect is with regards to the kind of transaction that is at hand. So Mohini provided us on the slides that the kind of acquisition or kind of disposal that we consider as buyer-sell transactions. In those, if somebody is doing an active transaction, and I'm using word active and passive here. So if somebody is doing an active transaction where the transaction is done out of his or her own volition, 100% involvement, those kind of transactions will be categorized as contra trade. Of course, if the compliance officer gives an exemption to that, that's a separate case. However, in case of passive transactions where the transaction, the timing of it, the quantum of it, say is not in completely 100% my control, there possibly we have to take a nuanced approach. And to a certain extent, that approach has also been built into our FAQs. If you look at our our FAQs, there we see that that kind of nuanced approach has been provided, wherein for transactions like ESOPs or transactions involving say a buyback or an open offer or an exit offer, a rights issue, those kind of clarifications have been provided. However, despite of all of that, we still get a lot of queries in respect to all such transactions and different scenarios. And possibly through this webinar today, we would be able to answer a lot of those queries. So with this, I guess I have possibly provided some background of why is that contra trade came into the picture. And I would say that in 2015, the contra trade, the name, the concept per se, of course, got enshrined in the regulation. But the intent of regulation from 92 itself was the same, that if you have information, do not trade. If you regularly have information, it's better to apply some prudence and not indulge into frequent trade. So with that, I would hand it over back to Mohini.
So you are on mute.
Okay, thank you very much. You have covered nicely, and I welcome Sudarshan sir. He has joined. So, sir, we were thinking you will come in between. So now you have come. So Naveen has given the idea of why the contra trade things has come and what is the logic. We have received various questions. So just if you can give a opening remark relating to your view on contra trade and why this has come. And what are the needs? Why this was the need?
Good evening, Mr. Pawan and his team for organizing this. Good evening to all of you. I understand that Mr. Naveen has already, given the views which are more or less will be the same. So what I will request is that if you don't mind, instead of giving my remarks at this point of time, let us take the questions, because let's see what type of queries are there, what type of doubts are there. We will address that first, and at the end of the session, if anything more need to be told, I will prefer to tell that. So I mean, I think because it's already 4:30, so people will be more interested to ask their questions and get the answers. So I think that will be more appropriate. I feel, please don't mind for that, for my saying that. I think let us go open the session and then go forward, please.
No problem, no problem, because you can understand 25 questions already there on the screen, and then we have more than 40 questions with us. So there are 65 questions we have to just discuss, so you can understand. If you can remove, there is some doubt, we will try. The basic object of this today's webinar is we will try and remove all problems, all doubts in the minds of our corporate world. So I'm starting with first question, sir. And please give the questions on the screen, please. So first question is whether contra trade, Narayan, this question I'm addressing to you.
Sure.
Whether contra trade restriction would be applicable on a collective basis to designated person or their immediate relatives, or on an individual basis only. Example, like DP has purchased the shares of the company, whether its immediate relative can sell off their holdings in the market.
So thank you, Pawan, for inviting me. And of course, both Mohini and Naveen has given a very nice prelude to why Contra had come. And I don't want to deliberate anything more on that. Coming to the point of this question, yes, Pawan, the code of conduct of the company framed under the SEBI PIT regulation is applicable to designated persons and their immediate relatives collectively. Hence, to answer to your question, if designated person has purchased shares of the company, then their immediate relatives cannot sell off those securities for a period of 6 months from the date of acquisition.
Okay. In case there is a dispute between husband and wife, then what will happen?
If there is a dispute between the husband, as of now, the regulation says every trade done by the spouse is as equal to be done by you. With regard to the spouse, there is no need of even getting into financial dependency or anything. But if there is a dispute and there is a divorce, and if they are no longer husband and wife, of course, this will not apply. But if there is a dispute, but they still live in the same address, then I don't think there is any exemption available.
So you have to prove that there is a dispute.
And you have shivered ties, correct?
Okay.
Yeah.
So welcome, Savitri, for this webinar. So next questions to you: whether contra trade restriction are for open market transaction or for non-open market transaction, or for both?
Thank you very much, Pawan. It's indeed a pleasure to be once again there in a program of corporate professionals. Contra trade restrictions will not apply to non-open market transactions. That is, if it is a corporate action done by the company, maybe in the form of a split, or with respect to a bonus issue, or with respect to any action like maybe an OFS. In these kind of cases, non-open market transactions will actually get attracted, in which case contra trade restrictions will not apply. All other transactions, the contra trade restrictions will apply.
Okay. Naveen, this open market and non-open market concept, which is, will you define in your FAQ, which is coming shortly?
So we will discuss these issues today as the webinar progresses, and then we'll try to figure out how to incorporate those in our FAQs.
Okay. Moini, do we have to check the contra trade restriction on date-wise transaction or by share-wise transaction? Like share purchase on 1st January, 100 shares. Share purchase on 24th February, 100 shares. When can the shares be sold out?
So in the contra trade, the contra trade restriction is the transaction wise, not the quantity wise. So if so on the 1st January, if you have purchased 100 shares, it cannot be sold off, and the 6 months period is to be calculated from the 24th February. So it's not on FIFO basis and not on quantity basis. You have to wait for the cooling period of 6 months from 24th February 2023, and then you can dispose of.
Okay. Any different view? If anybody has a different view other than the speakers, then please let me know. Okay.
Agree. Completely agree.
Yeah. Okay. So now, Naveen, whether contra trade is allowed if the trading details were already mentioned under the trading plan?
So yeah, the 1 point answer is yes. If the designated person has approved trading plan, and if the trades are undertaken in accordance with that trading plan, those trades will not fall under the contra trade violations. The same has also been provided under the PIT regulations as a part of 5.3, the proviso to 5.3. So that's enshrined in the regulation itself.
Okay, and trading plan you have to complete. That is a compulsory.
Yes, that's a compulsion. So if the trading plan has been approved by the compliance officer, that has to be complied with. So it is an irrevocable trading plan.
Okay. Okay.
Also, sir, to add this, in the trading plan is to be made public. It's gone on the stock exchange, so everyone is aware of that when that person is going to enter into transaction.
So
Just to add a little more, a trading plan cannot be conditional, which means it has to be absolutely specific and certain.
Absolutely.
And you need to give effect to the trading plan. It cannot be one where you say that you would want to buy only if the price is between X to Y. That's not permitted in India.
Okay. So you mean to say that trading plan is not reversible? You have to give this plan, and that plan should be on the public domain. Okay.
Yeah.
Absolutely.
Next, Narayan.
Yeah.
When the shares acquired in the follow-on public offer can be sold within period of 6 months?
So the answer is no. Designated persons cannot sell shares if it is acquired in the FPO till the expiry of 6 months. So Pawan, here in FPO, what we have to understand, FPO is subscription in a listed company shares. So this definitely falls under the definition of trade. The exemption for FPO, in fact, Naveen was also alluding that they will also try at their best now in the revised FAQs to define what type of off-market transaction or corporate actions are exempt. For FPO, the exemption is only given for any trades prior to FPO. That is, it is only acquisition of shares under IPO which would not attract restriction on contra trade. What I mean to say is that if you have done a sell transaction prior to FPO, then that trade will not restrict you from participating in the FPO within 6 months and will not be violative of contra trade. But once you get shares allotted in FPO, then subsequent disposal in open market will tantamount to trade, and you will have to wait for 6 months.
So you mean to say that I have sold shares today?
Yeah.
And after a month, I am getting FPO, I can apply.
Absolutely. Within 6 months also, you can apply. Next day, you can apply on that FPO. But once, sorry, go ahead, Pawan.
So that contra trade is allowed, but after acquisition of FPO, when you have participated in FPO, you cannot sell.
Absolutely. And like Savitri, in respect of the others, also very nicely lucidly summarized. If the logic, I think, is if the transaction is not a transaction where you subscribe, where you get automatic, like a bonus, split, merger, demerger, where there is no act of subscription. The moment you subscribe, it comes in trading and dealing of shares. But in a bonus, split, etc., there is no act done by the employee or designated employee. There, the way Savitri has nicely alluded, there you can do a sale even after. but not in case of FPOs where it's an act of subscription.
Okay. Naveen, you have any view on this? Because this particular thing, people are asking more and more question on this.
So, sir, as Narayan sir very clearly put it out that in case of if you participate in an FPO and prior to that you had say a sell transaction, that could not be construed as a contra trade. However, if you participate in an FPO, you acquire shares and thereafter if you sell, that would be considered as a contra trade. Similarly, in case of other kind of transactions, say a split or a bonus or a merger, demerger also, there both the side, the transactions are permitted both prior as well as post. However, there is one thing that we have to keep in mind, that say if this, say for example, if it's a split, so if it's a 1:1 split, I have 100 shares, I get another 100 shares. Now, these shares which I have received, these can be sold subject to the fact that the 100 shares which I have already have were acquired 6 months prior to the date of selling. So what I mean to say is that if today I receive the shares, the split shares, and the original shares on which these split shares I have received were acquired 4 months back, I have to wait another 2 months so as to get out of that the contra trade restriction. And same logic is applicable, say for a bonus or for bonus as well. For merger demerger, we again have to, for the purpose of calculation of 6 months, have to take into consideration the principle of grandfathering, where the original company which demerged or the original companies which merged and their date of acquisition of shares will have to take into consideration for calculation of 6 months.
Yeah, I think very important point, Pawan, raised by Naveen also, that this exemption can be availed provided the original transaction on which you are getting bonus, those were at least completely compliant with PIT. The only difference which the regulations create, where we said where it's an act of subscription, market sale can be done immediately after ESOP exercise. I think ESOP exercise is only the carve out which is not treated as contra. That means I can exercise ESOP today, I can sell it tomorrow. But there also, if you have done a market purchase before or after the ESOP and do a sale within 6 months, this market purchase, then merely by getting ESOP in between, one cannot get away from a contra trade. That is, any buy-sell trade undertaken by a DP within 6 months of an earlier sell-buy trade will tantamount to contra. So in respect of ESOPs, subscribing, exercising and subsequent sale shall not attract a contra restriction at all. Even if a lot of times question comes, even if ESOP shares are sold in multiple transactions, even if you're sold, even that will not come foul of contra trade. Of course, but in short, what I wanted to tell by introducing market is that there is a misapprehension in the minds of a lot of professionals that merely inserting an ESOP exercise in between two opposite market trades happening within 6 months will not allow you to do a Ganga Snan and clean your sin, which is otherwise not a contra trade.
Okay.
Yeah, actually, I would just like to add one point that has been very beautifully explained by all the panelists. I would just like to add that the principle behind this needs to be understood clearly. If you have not done any transaction, that is, a corporate action is one where the shareholder does not intervene in the transaction, or as Narayan rightly said, where the employee gets ESOPs. In these cases, the contra provisions are not applicable. At the same time, where it says that you can participate in the subscription of a follow-on public offer or a rights issue, as the case may be, it's only at the stage of subscription, because everybody gets it at the same price, but not with respect to the sale. That's the spirit behind contra.
Perfect.
Okay. Okay. Right. Okay. Next question relating to, I have asked FPO, now IPO. Mohini, whether shares acquired in initial public offer can be sold within a period of 6 months?
Yes. Reason being, through IPO, the company get itself first time listed. So after listing, whatever is the first trade by the DP, that should not be contra. That should not be contra in the future. So if after IPO, if you again purchase, then from that date, you can't sell it off for a period of 6 months. And if you have purchased again after IPO, you can't dispose it off. So IPO per se is not the first transaction. After listing, whatever is your first transaction, from there you have to calculate your 6 months period. So immediately, if you want to, you can sell it out.
So even the next day, Mohini, you can sell shares of IPO, correct?
But after that, you can't go for
You
purchase.
can't. Yeah.
So after that, suppose you have sold your shares, then you cannot buy.
You can't
Yeah.
buy because your first transaction is of sale, because the company is now a listed company.
So Darshan sir, one question to you, sir. Whether the company can disgorge the profit earned by the designated person while indulging in contra trade violation inadvertently. What if due to contra trade there is a loss?
See, if you really go by the legal meaning of the word disgorge, I think company cannot disgorge in that sense, because the disgorgement power is only with the regulator. But if the person has made a profit, the company shall definitely, ask that person to refund the money and also levy some, whatever is the penalty as per the code of conduct, the person will be liable to pay for that. Now, the question is, if a person incurs loss, now he might have incurred loss, fine, you can't do anything. But for having done a contra trade, for not having complied with the code of conduct, there will be a penalty as per the code of conduct that has to be levied. That is the only thing. But the profit will, in case of a profit has to be taken back. But I don't want to use the word disgorge because I do not know what type of legal issues it will create. So that is why.
But the saving of loss is also profit. Yeah. Savitri, what do you think? Saving of
Sure.
loss.
Yeah, so there are two parts to it, as was very beautifully explained by Mr. Sundareshan. If there is a profit, yes, of course, disgorgement is a right which only the regulators have. So it's not disgorging. However, you penalize and make the person make over the profit. What is typically done by the different companies is that whatever is the profit that is earned, the employee is asked to make over the same amount and deposit it into the IPF account. And also there is a penalty which is also charged typically based on the practice of the company. Now coming back to, there are two other aspects here. One, what if there is a loss? Even if there is a loss, there is a breach of code of conduct, and therefore, as is also given in the model code of conduct, there would be punishment depending on the quantum, depending on whether the person is a first time offender, as to what kind of penalty or what kind of disciplinary proceeding would be taken against the person concerned. It could be as simple as just giving a warning, right up to a monetary penalty being paid by the employee concerned, which also typically most companies ask the employee to pay over the money to the IPEF account of SEBI. There could also be another possibility where, let's say, you don't have a clear state of whether it's a profit or a loss. Say, for example, where the person has sold something during a window closure period, and the money that he would have possibly earned if he had sold after the window closure period had come to an end. How exactly would you then calculate? So, in such cases, whether it's a case of purchase or sale, you would come up with a notional profit. And based on the notional profit, you would have a penalty being charged. Like, say, for example, if it's a case of purchase, then you don't have a specific guideline as to how exactly you would be charging. So you would have notional profit, notional loss kind of calculation. Based on that, the companies would evolve and would ask the person to make over. In short, the breach is of the code of conduct. And if there is any profit which is made, or apparent profit or notional profit, that's also asked to be made over.
Only one point, Savitri and Pawan. While this saving of losses, what you're saying is, for the window closure, Savitri has very nicely explained. Only thing, if it is a mere contra, I don't think the compliance officer would need to. Suppose there is a loss on a contra trade, and it's not a trading window closure period. Okay, it's an open trading window. A person has done a contra trade within 6 months, and that is gets into a loss. Is it required for the compliance officer to say, I am not only going to calculate profit, I am also going to calculate the loss which he has avoided if he would have sold later? That means if it is not a closure period, I don't think the compliance officer will go for further period and say, I will track the movement of shares and then probably give a penalty on you.
Absolutely. It's only
I don't think that is possible. Yeah. So we do not have to go to that level is what I wanted to say. But window closure, yes, definitely notional profit does apply.
Okay. Now, the two compliance officers are here. There is one question. The PIT regulation provides disgorgement of profit in case of contra trade. Can the company code provide a higher penalty and subsequent remittance to IPA?
Definitely.
There is no bar.
Yeah, no bar at all.
So you can
see, it is like contra, suppose SEBI has prescribed 6 months. If the code wants to prescribe a period higher, they are most welcome. Similarly is the case with penalty.
Correct.
Okay. Narayan, recently you have given answer. So somebody has asked the counter questions of yours.
Yeah.
And Narayan sir's understanding, if someone sells shares first and then apply for FPO.
Correct.
Allowed. But my question is, this can also be intentional, because if he or she thinks when FPO comes, price will fall, then they can be benefited.
As I said, FPO is an act of subscription by you. So the only exemption can be said that if you have sold your shares, there is no bar from you from acquiring the shares even within 6 months. I don't think we are getting. The only thing is after FPO, you can't do a sale within 6 months. That means the act of that FPO, once you acquired, then you are required to at least keep it for 6 months so that it is not contra.
Okay.
Yeah. Just one point here, I mean, absolutely perfectly answered. So when you're saying that the person anticipates the price to fall after the FPO, the moot question here is, did he know that there would be an FPO? If the answer is yes, that's one which would have been an upsee where he should not have sold at all. But that's a different issue, not related to contra, please.
No, but perfect. I think very nicely alluded, Savitri, because that will come under the basic premise of a self-test everyone has to go through, that I'm not going to trade while sitting on any UPSI.
Absolutely. Absolutely.
Okay. Next question, question number 8. If designated person, DP, Savitri, this question I'm addressing to you. The designated person is holding shares under his pen in different capacity, like his personal capacity, in capacity of trustee, in capacity of executor or will the restriction of contra trade will applicable to all the shares held in all the capacity collectively or individually?
Actually, Pawan, this particular restriction of contra is applicable at the PAN level. So therefore, it is irrelevant as to in what capacity he is holding it. It will be applicable to all capacities collectively.
Okay. Naveen, can you explain that suppose I'm an executor of somebody's will? Say I'm working in the company and they've appointed me. Now this restriction, and there is a decision of certain things and they have to sell shares. Now I can't sell my shares. Is there any logic for this, that pen based is not a restricted?
Yeah, the point that you're making is making sense, but then yes, as under the contra trade the regulation, it is applicable at the PAN level. So as it stands today, yes, in whichever capacity you are in, this would be applicable.
Okay.
Only point, Naveen, is whether under Regulation 4 they can prove their innocence, that it does not probably belong to me. This trade was done as part of probate which is given by the court, and as an executor. That will have to really be seen. Whether they can prove their innocence under the provision to Regulation 4.1.
Correct. Yeah. So that's a very on a case-to-case basis. Yeah.
Okay. Next question, Naveen, this is for you.
Yes, sir.
what is the relevance of cooling period of 6 months to execute the opposite trade? Why not 3 months? Why not 9 months? And sometimes 6 months is not a higher side.
Yeah. So as I in my initial remarks was telling that the concept of contra, when it was introduced with the words contra trade in 2015 regulation, a period of 6 months was introduced, and this was done after deliberations, both internal deliberations with the market, the feedback that we had received on the public consultation paper. So of course the period of 6 months may be debatable, but yes, there has to be a cooling off period of 6 months so that nobody who has information day in, day out indulge into some kind of speculative activity, especially when in possession of the information. So that's why this was 6 months was started. Yeah, so that is how it stands today, sir.
And Pawan, if you see the same 6 months, they have used it even in connected person. That
Correct.
means even if a person resigns from the company, said the regulator broadly believes that it will take 6 months for whatever information you have to broadly get into public domain. So hence you say that even if a person resigns, he will cease to be a designated person, but he continues to be a connected person for 6 months. I think 6 months, probably that's the logic, is what I understand.
So Narayan sir has put it like really rightly over there, that if you look at the connected person definition, where essentially what the essence is that the UPSI is supposedly it exists for a period of 6 months. So from that context only, this 6 months can also be drawn.
So anything below 6 months is speculative in nature.
Yeah.
At least hold it for 6 months so that if at all, whatever it is, you are able to basically prove yourself.
Also in the law now, in the last FAQs, when the SGD, it is released that when the UPSI is germinated. So UPSI is germinated, it has been explained, then when the probability of going ahead with that season is more than the probability of not going ahead. So from where you have started that, yes, now we are going ahead with this season. So I think the logic behind 6 months is that the transaction is definitely be taking a final shape within the next 6 months. So this period is from the when you have decided. It's not when the thought has came in the mind of the management on.
Okay.
So in some ways, it is more like a life of a UPSI is considered to be 6 months.
Okay. Very interesting question. Whether the sale by broker to meet the low margin requirement will fall under the contra trade.
Interesting question. So to my mind, if such kind of trade is happening, the designated person should have taken that in consideration, because as it stands today, if any trade happens within 6 months, that will be categorized as a contra trade. So whether that has been done by the broker. So when a designated person is entering into any such transaction where he has to provide the shares of the company where the person is designated as a designated person, so all these factors have to be taken into consideration. So yeah, so that will be categorized as a contra trade.
Because what happened, in my opinion, I told my broker, sell the shares. I can design this and tell him, and I'll tell my designated, my compliance officer, because there was a shortage of margin, so he has sold my shares. So I think your answer is correct, that this should come in the contra trade.
It should come in the contra trade. So I, as a designated person, should have taken that into consideration when I was placing my trade, when my positions I was taking through that broker, knowing very well that if such kind of scenario arises, he may sell off my shares, and then this will tantamount to contra trade.
Yeah. Mohini, if any designated person has acquired the shares from the market and post that he is disposing of its holding in the market in multiple tranches within 6 months period, so whether all the disposal transaction after the purchase of shares will be deemed to be contra trade, or only the first disposal will be deemed to be contra trade. Though you have given answer in your presentation, but I'm just because somebody has asked, so please explain.
Every transaction, even the subsequent multiple transactions, be deemed to be a contra trade only, will be treated as contra trade, not deemed. It will be. Otherwise, it will be a very easy for a person First trade is a contra, and the subsequent sale, they can sell the larger quantity in the later trenches. So because first is contra, that action will be taken on the lesser quantity. So all the subsequent transactions should be treated as contra, not the first transaction only, because otherwise it will be giving a very good hand on the part of the designated persons to avoid this contra.
Okay.
And can make the profits.
Okay. So some of the questions which has come recently by the public, they have posted there. Savitri, first question. In case of intra-trade, when the, no, please hold this. In case the intra-trade, when the shares don't come into one demat account, how will the compliance officer ensure compliance of contra-trade by designated employee?
So actually, the question is not whether the compliance officer has to ensure contra-trade compliance or not. It's for the designated person to ensure that all his trades are in compliance with the code of conduct of the company, which of course is designed in accordance with the provisions of PIT regulations. So whether he's got delivery or not is secondary. He knows that he has transacted, he's going to get delivery. So he is aware of all his transactions. Now there's just one point here. It's quite possible that there may have been a portfolio management scheme to which he may be a member, and therefore he may say that he is not aware of it. Actually, if it's a PMS scheme, it is very important and absolutely imperative for the DP to ensure that he treats the scripts of the company in grey list and gets a confirmation from the PMS manager, because that's one area where there can be issues. So coming back to the question, compliance is basically on the designated person concerned. The compliance officer is merely facilitating the compliance and ensuring compliance of the code of conduct. The obligation is on the designated person. That does not shift.
Okay. Yeah. Okay. Okay. Naveen, if the director gives shares to a daughter, how will contra trade work?
So, sir, this has actually been clarified in the FAQs itself that gifting of shares will tantamount to dealing in shares. So that would attract contra trade provision. So even if the director is gifting shares to his or daughter, that would be contra trade. Of course, if the earlier transaction was done in compliance with PIT regulation, the 6 months have passed, the contrary regulation will not be applicable. Otherwise, it would be.
Okay. So acquisition by any way, that will be contra trade.
Yeah, correct.
So whether shares inherited are also acquisition?
Shares inherited. Now, shares, if are inherited, they are being bequeathed upon someone where no active involvement was there. So say if the shares are inherited upon someone's death, now that is something which is not in the hands of the, so suppose the person who's receiving those shares is a designated person, those are not in his hand. So to my mind, if the act has been done, which the person has no control upon, that should not be categorized as contra trade.
So
it is,
yeah.
So it is clarified, Pawan, that transmission of shares, contra does not apply for transmission of shares. This is clarified in the FAQs also.
Okay, just tell me, Narayan, you are saying the transmission will take place when the court will pass an order, or you have suppose you have a will and then you are going for execution.
No, the transmission of shares will happen when the shares actually come into your demat account. Okay. That means if the shares come to my demat account, and if it is within 6 months of an earlier trade, I can possibly tell the compliance officer, if suppose it happens to be during a window closure and the compliance officer is monitoring, you'll have to prove to the compliance officer, this is a probate, this is a bill on account of which these shares are transferred to me. And because it is transmission of shares, it will be exempt.
Absolutely. Also, in case of transmission, there are different ways. One is where the shares are held in demat form and there's a nomination which has been made, in which case, you don't even have to wait for anything. Directly, the shares will get transmitted to the nominee. The other possibility is where they apply for transmission. Now, they would be applying for transmission to the DP, and it happens. So what happens is the designated person sees that there is a credit to his account, and the compliance officer raises a query, gets to know that this is the way in which it has happened, and therefore there is no further compliance because it's clearly a case of compliance, clearly a case of transmission. I'm sorry.
Okay, Savitri, question for as a compliance officer, husband and wife both belong to promoter group. If husband gives some share as gift to his wife, does it at all fall within the mischief of contra trade? Answer Naveen has given. If yes, how do we address contra trade issue in case when one person acquires, another person dispose of?
So actually here you have to treat both the husband and wife as one unit, because if you don't treat them as one unit, you will actually have instances of mischief, because one would be buying and the other one would be only selling, and they may be having their own holding. So when you're looking at contra trade, it is, if the husband is buying and the wife is selling within a period of 6 months, while the law has not very clearly provided so, I would say you need to read it in conjunction and treat this as one unit and treat it as contra trade.
Okay.
So Pawan, this is again homework for us, because whether it is husband, wife, or father and son, or daughter which came, if it is inter se, could we probably clarify in the FAQs that treat it as a single unit, like Savitri said?
Yes.
That means it is not that the husband can, it is not a case of husband doing a market trade and wife doing. That's not the case. If the husband is doing a purchase and the wife is doing a sell, definitely. But inter se, if it is a case of give, can be treated as a single unit is something we should consider in the FAQs.
I'll come to the interstate transfer. Separate questions are there.
Sure.
There is some issues in this. Okay. Mohini, designated person after leaving the organization will be categorized as connected person. Are connected person required to follow contra trade and other restrictions mentioned in PIT regulation for the period of 6 months once they leave the organization?
No, the code of conduct is applicable only till he remains the employee of the organization. So once he leaves the organization, definitely contra trade provisions are not applicable. But yes, because if he is carrying any UPSE with him, then he has to be taken care of while.
Narayan and Savitri, you have any different view?
No, I fully agree. What's important is designated persons, the compliance officer also monitors on a regular basis just to see whether the code is complied with or not. Since the code is not applicable to a person who's not in the employment, he becomes a connected person and he remains a connected person for a period of 6 months. The provisions need to be complied with, because the PIT regulations refer to the term insider, and a connected person is also an insider. So what is important is that person, the ex-designated person, will have to ensure that he complies with the provisions of PIT regulations, which means he cannot deal in the securities of the company so long as he is in possession of UPSE.
Okay. Now,
but no pre-clearance, none of those are applicable once he ceases to be in the employment.
Okay, Naveen, this question is for you. How the UPSI restriction and contra trade restriction interlink?
Sorry, sir, I didn't get that.
How the UPSI restrictions and contra trade restriction interlinked?
How UPSI restriction and contra trade restrictions are interlinked. Okay. So we all agree with the fact that if someone is in possession of UPSI, you should not trade. That's the basic tenet of the PIT regulation. Now, with respect to contra trade, which is applicable, and we just discussed on designated person, who are essentially in employment of the listed entity. So someone who is a designated person and where the likelihood of having such information is very high. Generally, such kind of price sensitive information, whether it's unpublished or not, is generally there. So there, if such persons are trading frequently, the suspicion rises that is some kind of a speculative activity. And then every time for the person to justify that, no, this trade was not done on the basis of a UPSI, and for the compliance officer also to look into it and manage it becomes challenging. So there should be a prudent policy framework where such people who are generally have such information should refrain from trading frequently, and for that period is 6 months. So that is how I feel the UPSI is tied with the contra trade.
Okay. So these are some general question. Now I'm coming to the specific question of exemption from contract trade. So just these are the some. First question is, Moini, which kind of transaction trade will not be fall under the ambit of contract trade restriction?
So earlier also we have covered this, that the transactions which are available to all the shareholders, we can say, or to a general public, like FPO, rights issue, any bonus which is coming to you as because it's an action pushed from the company, that is exempt from the contract trade restrictions. But other wherein you are actively involved, other than the FPO and rights issue, all transactions are considered the contract trade restrictions are applicable on that. So
Okay.
only the non open market, we can say, the transactions are exempt from the contract.
Okay. Narayan,
Sir, I have a point here.
Yeah,
So
good.
we, of course, did put that that the difference between an open market and non-open market transaction. But even in respect of non-open market transaction, we cannot give a blanket non-contra trade stamp on all such trades, because and we have discussed that earlier as well, that say in case of an FPO, if I sell first and then do and participate in FPO, that will not be categorized as in contra. However, if I participate in an FPO and then sell those shares, that will be categorized as contra. So we have to look into the context as well while deciding the fate for a transaction where a non-open market transaction is linked in that. So if it's an open market and non-open market transaction, both coupled, we have to look the context and then accordingly see whether that will be categorized as a contra or a non-contra.
okay.
But Naveen, if you just like Pawan had alluded in the beginning,
Yes,
if
sir.
you just give logic, so the logic is any transaction which you are doing an act of subscription, whether it is an FPO, whether it is a rights issue, that will not give you exemption for a trade to be done immediately after that subscription, because I'm going to treat that subscription as market, as if it's a market trade. But if it is something not done by the designated person, a bonus or a split or a merger or a demerger, where shares just come to your account without your act, that could probably, and we could probably clarify it in a better way also in the FAQs.
Okay. Now, Narayan,
Yeah.
as SEBI PIT regulation, exemption from the contract trade restriction can be provided to designated person by the compliance officer. What are the scenario circumstances under which exemption can be provided to designated person? Because
So,
our burden is on compliance officer, so how you can decide?
So compliance officer is empowered to grant relaxation from the application of contra. And when you're doing, it will have to be for bona fide reasons to be recorded in writing and not oral. And provided that, of course, if at all I'm giving or any compliance officer is giving, this relaxation does not otherwise violate these the PIT regulation. So basically, we say that the compliance officer, before giving any relaxation, there are standard undertakings which we take from the designation, the DP, that you do not possess any UPSI, justification for doing the contra trade, legal obligation for indulging in contra trade. Is it something which is a pledge or a de-pledge? And broadly, after the undertaking, getting yourself satisfied of the bona fides of the transaction and document such process, so that any investigation coming later on by the regulator, you are able to prove that.
Savitri, you have any?
Just to give an example, let's assume, few situations. Narayan has very clearly explained the concepts. Let's say, for example, there's a medical emergency because of which the person needs to sell the shares. And as I was saying, the husband and wife would be treated as one unit. Let's say the husband had bought large number of shares, and now because of a medical emergency, the wife is required to sell the shares. This would be treated as a contra trade, and permission would be granted because it's a bona fide purpose. And just as Narayan mentioned, you would of course have a very clear documentation done in this case, and this would be considered as a valid one. Or it could even be, where the person has bought a house and he's liquidating the shares so as to be able to pay for the purchase. So these are the ones which would be considered as absolutely bona fide purposes. But if it is anything which is not considered as an emergency kind of a situation, it will not be considered to be reasonable ordinarily.
Also, to add in this, contra trade exemption is only from contra trade. Designated person should not make it ki if I am going in the trading window closure period and if I seek a contra trade provision exemption, so it will be exempting me even to trade during the trading window closure. So it's only for the contra trade, and contra trade exemptions will be given only when the trading window is open. He can't come and seek an exemption during trading window closure period.
Perfect. Good point.
Mute, sir.
This question to Savitri and Narayan, as a compliance officer, suppose I have come to you and you are siding me, you are favoring me, and can you give me relaxation?
Siding, I didn't get this point. Basically, what I'm saying is, if it is an objective way, you can do if you are talking on the same point of giving waiver or relaxation from the strict provisions of contra trade. The key point is, if we do an objective assessment of the person not having UPSI, telling what are the bona fide, is it really an emergency? There will be some amount of subjectivity, but within that subjectivity, you will have to remain objective with a good documented process to say that you've been fair. It cannot be that suddenly I treat one designated person reason as emergency and the same reason somebody else is given. I'm saying, so sorry, I'm doubting you. It will have to be on an objective basis.
Okay. Now, friends, I have so many questions. So we have to give answer that is most important. So very brief we have to discuss. Now, next question is on ESOP. Savitri, though Mohini has given this answer, but whether the cooling period of 6 months need to be followed between ESOP acquisition and ESOP disposal. Suppose ESOP exercise on 1st January, 100 shares sold on 24th February, 100 shares, whether such transaction is allowed.
Assuming there have been no purchases made by the person other than just ESOP as has been shown on the screen, there will be no problem, it will be allowed. Narayan had also mentioned a little while ago that with respect to ESOPs, there is no problem provided there is no purchase from the market in the intervening period. Because that's a genuine transaction of ESOP acquisition, that is where you have exercised your right, and ESOP shares being sold, no problem.
Okay.
Yeah.
But even if you bought one share from the market, sorry,
yes,
you lost your exemption.
Yeah.
After sale of ESOP share in the market, can the designated person purchase the shares within period of 6 months?
So, Vijay sir, Narayan sir and Savitri madam both have expounded the basic principle in respect of ESOP that so if I exercise my ESOPs, I get my shares, and if I sell that. Now, if there is any market transaction prior to that in 6 months, this ESOP exercise and then subsequent sell, this will not save me from the contra trade provision. Same way, if tomorrow so let's suppose there was no transaction earlier. The first transaction was an ESOP exercise where I get the shares, then I subsequently sell them. Now, when I sell them, that's an act which I have done on my own. Currently, the regulation provides you from an exemption that if you have got ESOP shares, you can sell them. That's fine. But then afterwards, if I go and make a market buy, that will be contra to the ESOP shares which I have just sold, if that the period is less than 6 months. So, ESOP shares exercise, I consequently get acquiring shares. After that, if I sell share, and if that gets interspersed with any market transaction of a buy, that will tantamount to be a contra trade.
To add in this, if ESOP exercise is there, then you can sell off immediately. If further you want to exercise your ESOP, you can do, and then you can again go and sell your ESOP shares. But in between, you can't add any purchase of shares from the market. But if only you are doing your ESOP exercise and you are selling your ESOP shares, yes, that you can do even without restricting for a 6 months period.
Okay. Naveen, if any designated person has acquired shares of the company from the market, whether he or she is allowed to dispose of shares through ESOP within period of 6 months, I think this answer you have
This
given.
answer we have already answered.
Okay. Next query is related to derivative contract. So, Narayan, in case of designated person enter into future contract of near, mid, or far months contract on expiry, will it be tantamount to contract rate?
Generally, if it is settled on the expiry, it is not generally considered as contra. However, if you close the transaction before the expiry, then it would get into the clutches of contra.
So you do trading in the optional future also, it means?
No, oh my God. I am far, far away from the market.
Okay.
Far,
Absolutely.
far away.
Whether rollover of contract in the equity derivative segment is considered to be contra trade?
So actually, Pawan, this answer is very similar to what Narayan just mentioned. Now, when you do a rollover, you're consciously taking a position. So when you're taking a position and you're saying that you are rolling over, that's a transaction and hence contra provisions will apply. This is a debatable point. However, conservatively, this is the stance I would take. Invite Narayan also to give his views on this.
Okay.
No, I agree.
Okay.
Go ahead.
Naveen, I think on the questions which we have received on the screen, I'll ask Vaibhav question later on. There are so many questions coming on pledge, and I think this if people are asking pledge questions, there is some confusion. First is whether creation, revocation, invocation of ESOP pledge shares considered as contra trade.
So, creation, revocation, and then subsequent, so creation, invocation, revocation, all of them, to my mind, they tantamount to the trade. So if it's a creation, if it's a invocation, that would be a sell transaction, and if it's a revocation, then it would be a buy transaction. So to my mind, though this we of course have to seek views of other panelists as well. But then on a conservative side, this will be categorized under the contra trade, again within the principles of whether such transactions are done within 6 months or so. But yeah, I would love to hear the views of Savitri Madam and Narayan sir on this issue.
So Pawan, as far as when we were clarifying for ESOPs, what did we say? If there is any acquisition or disposal, acquisition or sale, which is a market transaction, that does not prevent you from contra. That means only the shares acquired under ESOP, you can sell it within 6 months. But in between, either prior or after there is a purchase or sale, you can't. If you use the word purchase or sale, what Naveen is trying to just broadly expand that to say that if I pledge my shares, it will be treated as acquisition of shares. If there is an invocation of a pledge, it will be treated as sale of shares. It is a revocation of pledge, it will be treated as acquisition of shares. And if you say this is one point where right in the beginning, Mr. Sundaresan would also remember, we've had a lot of discussion with the regulator where the regulator is very clear. We are not going to exempt pledge, whether you create, revoke, invoke, revoke, from the ambit of trading. And if you see the consolidated FAQs, which they had released, I think more than a year back, the first question which they have addressed is pledge in any manner is trading. And if pledge in any manner is trading, then it will become difficult if you do a two opposite transaction. That means you pledge and then revoke the pledge. You can't do it within 6 months. And that need not, this question need not be addressed only with regard to ESOP. Will be confusing. Even right now, even if you want to just pledge your share irrespective of ESOP, if you are pledging the shares, it will be treated as ESOP, as if you are, as if the shares are being sold, and when you are revoking, as if it is being acquired. Similarly, if the lender invokes, it is again a sale of shares. So once that concept is clear, and the concept that you cannot get this concept out of trading, I don't think we've got any much leeway to discuss.
There's just one point here. When you avail of financing for purchase of ESOP shares, it is pretty common for the financier, that is an NBFC as the case may be, to ask for a pledge of the ESOP shares, because you may be entering into a sell to cover kind of transaction, in which case the entire ESOP shares, I mean, in fact, they take it right at the stage of entitlement, even before you have been allotted the shares, with a condition that all the shares which get allotted upon exercise of ESOP shares will stand pledged, and thereafter they would sell from those shares. So there is a complicated question here, and in such an event where you are merely pledging it for the purpose of getting the finance to be able to subscribe to ESOP shares, or rather, let me use a technical word, to be able to exercise your ESOP options. In that case, I think we will need to clarify a little more when we look at this, because if it is purely for this, it will need to be facilitated. But otherwise, if you are doing, just as Narayan explained, a transaction of pledge, of course, it will be falling under the contra provisions. So actually, contra provisions, for that matter, there is another tricky situation where you depledge and again repledge. Let's say, for example, you've got your shares pledged absolutely in a proper manner with one agency, and that particular entity decides to stop the business. This has happened in the market. So you move from this agency to another agency. Now, this process will actually involve releasing it from the pledge and once again creating a pledge. Or let's take another scenario where you have availed of a loan and given pledge of shares. It could have been for a medical emergency also. And then you're releasing the pledge to go to another bank who's willing to give it to you at a lower rate of interest. These are practical scenarios. Not everything can be answered just across the table. Probably these are the ones which will need to be studied, understood, and relaxations considered in the fitness of things.
But Savitri, the point only which you rightly said, the only way I see, like the way we said pledge and repledge, depledge and repledge again, or relating to ESOP funding, the only way I find right now, the fact that pledge is equal to trading, the only way I see is compliance officer using probably the discretion and giving a leeway from the exemption of contra for bona fide reasons. If that's the only way, probably this could happen. Otherwise, it looks difficult.
Absolutely. That's exactly the way it will have to be implemented. I was just explaining the way things play out.
Practical difficult. Yeah.
Moni, you have any additional point?
No, sir, because ESOP, yes, it's by using the leeway of that exemption from the compliance officer, they can get the exemption and they can pledge. Because definitely it's for the financing of ESOPs only. And ESOP exercise is per se exempt. So I think we can take a benefit of that thing.
Okay, now, do the employee need to hold the shares for a period of 6 months before depledging and selling if he has availed the financial facility at the time of exercising or ESOP shares and the lender had pledged his shares, since there is no restriction on contra trade for selling of ESOP shares?
So I think already we have covered
this in detail.
Okay.
Absolutely.
Okay. Now, some questions on buyback. So, first question is, if designated person, Naveen, I think I request you to give the answer. Because these are the two questions which are on a policy matter. If designated person has acquired the shares of the company earlier and post that the buyback announcement came from the company, whether designated person is allowed to tender his shares in the buyback offer within 6 months of purchasing of shares of the company.
So the designated person has acquired the shares once the buyback announcement has been made.
Yeah.
And then subsequently sells it in the market?
Yes.
Is that the question? Okay. So, sir, if the so in a buyback, of course, they are participating. So somebody, so let's take example of any person. So if the company makes an announcement of the buyback, any person in the market goes out and buys it and then tenders those shares into the buyback. So that is something which is available to all the shareholders.
Yeah.
So that, to my mind, will not be categorized under contra trade. However, if so the UPS I think will also not be applicable. So yes, if somebody just acquires it even after the buyback announcement enters it, will not be categorized as contract.
Contract.
Another question, Naveen. If
Yes.
designated person has acquired the shares of the company after the buyback announcement from the company, whether designated person is allowed to tender his shares in the buyback offer within 6 months of purchasing of shares of the company?
Yes. So it's the same thing that now I have bought the shares earlier and then the company announces the buyback. I tender my shares. I'm the designated person. That will not be categorized as a contract, sir.
Okay.
Yeah.
Mohini, now I have to ask rapid round. I have started, so I have to ask questions on fast basis. Mohini, if the securities are disposed of through buyback or open offer, then the designated person can subsequently acquire the securities of company within the period of 6 months?
No, you can't.
Okay.
Because in the buyback, you have self-tendered. So now you can't go and purchase the shares from the market.
Okay. Now, few questions on right issue. First question to Savitri. If the designated person has earlier sold off shares in the market, so whether he is eligible to apply in the right issue offer of the company within 6 months of the earlier acquisition?
To put it in one word, answer is yes, he can certainly apply. I would also like to add that in line with the circular of SEBI dated 22nd Jan 2020, even if he has sold off the rights entitlement and subsequently applies for the balance rights that he has, that will also be permitted. It will not amount to a contra.
Okay. Narayan, as we are aware, the right entitlement can also be traded in the market. The designated person can trade in the right entitlement if he or she has earlier acquired the shares of the company within 6 months period.
No, they can't sell right entitlement because that will also be treated as a trade within a period of 6 months.
Okay. Now, a few questions on merger, amalgamation, and demerger because that is a very complicated and the date of 6 months calculation is very important.
Yeah.
Okay. So, Naveen, first question to you. In case of merger, amalgamation of two listed company, two listed entities, which shall be the trade date from which the period of 6 months shall be calculated for contracted?
So to put it very straightforward, sir, we have to apply the principle of grandfathering. So the shareholder of say A, shareholders of B, if they're getting after merger the shares of C, so whichever date they were holding their original shares in A and B, that would be considered as a date from which 6 months has to be calculated. So we cannot consider that the date on which C got created from that day, 6 months to be calculated. That's not the case. We will apply the principle of grandfathering here.
Okay. So, Mohini, you have any view on this?
So no, it's correct because you have earlier acquired and then you are getting the shares in the merger. You are a listed company designated person only. So you can't enter into opposite transaction being the continued designated person in the listed company. Simple.
Okay. I mean, the same question in different way. If an unlisted entity get merged, amalgamated with the listed entity,
so
then period of 6 months of contract rate shall be calculated.
I would again take the example of same A, B, and C. If A is listed, B is unlisted. B gets merged with A or AB gets merged and C is created. So the entity which is B, which is unlisted, there the date would be considered from the date when the companies got merged and the listed entity emerged. So from that date, the 6 month has to be calculated.
Okay.
Right, because in these cases, generally, I think the persons who are a part of the unlisted company, and because of the merger, they become the designated person of the listed company. They are becoming the shareholders of now a listed company. So I think the first trade they will be doing after being the company merged here, that will be I think the point for the further trade.
Okay. Mohini, the next question after the demerger of listed entity, the shareholder will get the shares, both the demerged company and the resultant company. So the period of 6 months for a contract rate shall be calculated from which date?
I think in the original entity, when whatever the transaction they have done earlier, that is to be continued in the demerged undertaking. In both the companies, it should be considered. Any others view in that?
Narayan and Savitri, any other view?
No, it is right. From the date of dealing in securities, the original securities only.
Okay.
Yeah, absolutely.
Next question. Now, few questions on bonus and split shares. Okay. Now, bonus, if the shares are acquired through a bonus shares, bonus issue, share split, then will subsequent disposal of security within 6 months be considered as a contra trade?
No, we discussed this earlier also, no.
Okay. Naveen, any different view?
No, sir. We had discussed this earlier. Same.
And of course, the rider which Naveen gave, that 6 months will be calculated from the date on which original securities on which bonus were issued, that will be calculated, not from the bonus date.
Correct.
Okay, Naveen, what is the logic of split shares including in this? Because split, you are 10 shares divided into 1 shares. It's not a acquisition, not the sale. So why we are including split shares?
So, Vijay sir, if we look at it, essentially nothing is changing in respect of these split shares. So one becoming 11. So one which I had acquired, let's say, so this happened today, this one share I had acquired 4 months ago. So even this one share I can sell only after 6 months, which is 2 months after this date on which split happened. So same treatment is also been accorded to all the other 10 shares as well. For there as well, we are saying that the 6 months will begin the date on when the original share was bought. So there is no change in status per se. So we are in fact going, so and that's the same thing that the same logic is also applicable for bonus.
Okay. Now, few questions on family settlement. Savitri, in the process of voluntary dissolution of HUF, if the designated person has received some shares of the company, so whether he or she can sell those shares in the market or a cooling period of 6 months is required in this case?
No, he cannot sell. The contract trade provisions will apply. Just as the question very clearly brings out this fact that it's a voluntary dissolution of HUF, which basically means you are in a position to arrange your transactions in such a manner which is beneficial. So therefore, the contract provisions will apply. This will be distinguished from a transmission kind of a situation.
Okay. Naveen, if the promoter do inter-C transfer, inter-C off-market transfer, does this transaction will fall under the ambit of contract trade? If yes, whether promoter can further trade within the period of 6 months?
Promoter is doing an inter-se off-market transfer. So it's essentially a transfer between the set of entities which are part of the promoter group. I guess the regulation somewhere provide for
Regulation 4,
Yes.
provide for the exemption on this, sir.
yeah.
So when
Inter-se is
both of
exempt.
them are in possession of the same set of.
Same set of
Same
details.
set, yes.
So
So
both
there
the
should be no
person
dissimilarity.
same. Okay. One more because they
But sir, here in this is that one they can do the inter-se, but it not be a via media that after the inter-se, the sum of the transferee will sell off the shares in the market. So first trade is exempt, but you can't say that that is free. Now I can sell those shares.
Yeah, so there are certain basic principles. What cannot be done directly cannot also be done indirectly. That's a basic principle that needs to be followed.
Okay. In Narayan, in case of family settlement transaction, if any designated person acquires some shares of the company and post that he wants to sell those shares, so it will fall under the ambit of contract trade. If yes, whether the compliance officer can provide relaxation to designated person in this case.
It appears family settlement also, the way we talked about dissolution of SUF. Family settlement, if it is done, I don't know. I don't think we can really give them the same status of transmission of shares and exempt it. And hence, if there is a family settlement happening, probably again, the compliance officer will have to take, and if the person goes, then they will have to take that route and exempt the transaction from contra.
Okay. So these were some questions which we have printed, but now I have just now I got so many questions. So I'm asking, and please, everybody should confine to their short answer. Now, ESOP, whether there is any exemption to contra trade transaction of the creation and revocation of pledge on shares of exercising of ESOP, Moini?
No, per se, no exemption is there, but yeah, through compliance officer, you can take.
Okay. Narayan, if shares taken pursuant to exercise of ESOP will also fall under acquisition from off market?
No, sorry, if shares acquired under ESOP can be sold in the off market.
So if shares taken pursuant to exercise of ESOP will also fall under acquisition from off market, because
No, need not. There's no point of falling under off market. Exercise of ESOPs are completely exempt both under the regulations and FAQ. So they need not get into off market at all.
okay. When you have given answer to this query, but I'm asking where regulation apply to securities which are proposed to be listed as well. So considering this, would contra trade be applicable to shares acquiring in IPO? Because you
Proposed to be trade, there are few provisions which is applicable for the proposed to be trade and not the entire regulation. So we have to read that regulations in that context.
okay. Savitri, this is a F&O question. Whether squaring of the buy or sell position in F&O market would also be contra trade?
Squaring in the ordinary course was also explained by Narayan. If it is squared off in the ordinary course, it will not fall as a contra trade.
Okay.
If you do a rollover, it will.
Okay. Naveen, out of two promoters who are brothers, one creates pledge and one revoke the pledge of their own shares of the company, and then they undertake inter-se transfer of shares as from one promoter to another, as pledge shares cannot be transferred. Will it be considered as contra? All questions he has done.
Yeah. So it's in different parts. All the panelists have provided answer to this, and this being a very complicated topic. So yeah, these kind of things and such complicated matters we have to debate, deliberate, and then possibly comment upon.
On a lighter note, Pavan, Naveen is saying, send me the case.
Informal guidance, huh?
But Naveen is not he's a regulator. He don't invite, okay, like professional like us, that you take opinion from us.
No, he might just send a show cause notice.
Yeah, Savitri, you have any answer on this?
No, I think it has been rightly answered, saying that it's a complex question where you have several parts to it. All that I would say is please tread with caution. The different parts do not really seem very congruent to me.
Sure.
So what we'll do, this we will debate and we will answer to. Anybody, the person who has asked question, we will reply after talking to all of them.
Yeah, but Pavan, one answer, it doesn't look doable because one is doing a pledge, the pledge is equal to sale. The other person is doing a sale, if it is a relative, correct, immediate relative of the designated person or promoter. Both of them can't do an opposite trade, correct? That's the basic premise. We can discuss later.
Yeah.
Okay. So now, Mohini, ESOP, there's one question. The company allotted 1,000 ESOP to any DP on 1st January. And after that, he bought 500 shares from open market on 2nd January. In this case, can he sell up to 1,000 shares on 15th January 2023 without restriction of contra trade?
No, because after ESOP exercise, he has again gone to the market and purchased the shares. Then he can't go for an opposite
He can't. Absolutely right.
Okay, ESOP shares exercised and sold within 6 months, but a possession of UPSI, which key managerial person are deemed to possess all the time, when ESOP shares can be sold by KMP.
No.
Basic principle of regulations you have to follow. You can't sell any shares when you are in the possession of UPSI.
So basically, exercise of ESOP during trading window closure is permitted, not sale.
Correct.
That's the question. Answer he's probably looking at.
Actually, this is a very interesting question, and I would like to step in here, where the person knows that he's going to exercise. My advice would be, please apply for a trading plan and get it publicly known, because you know the exercise price, you know the time when the vesting would happen, and in case you're also desirous of selling, please take that chance and put a trading plan together.
So if you are already pre-planning this, please do a trading plan, correct?
Exactly.
Okay, yeah, definitely.
Okay. Now, Naveen, what is the logic for making contra trade applicable to debenture, as one cannot fluctuate price of NCD?
Correct, sir. But see, the PIT regulation as it stands is applicable on all the securities. So the securities defined under the SCRA regulation, the contract requirements are applicable on them. Debentures also fall under the same definition of the securities under SCRA, and the contract rate therefore gets applicable upon them as well. And these are market traded securities. No one knows what could be the reason for the security price, the debenture price to go up or down. Especially if suppose some company, the insider knows that the company financials are not in good shape, and possibly once the results are out, the debenture prices may go down. So those kind of transactions, no one can rule out. So it's better to trade with caution, and that's why all the securities are covered under it.
Okay, Mohini.
I would just like to state that in case of debentures, Pawan, just as you rightly said, that the return is very clearly determined. It may be worthwhile to examine as to whether only sale of debentures should be regulated. Because let's assume, God forbid, the rating goes down and someone then sells the shares. At the stage of buying, everyone is going to be at the same footing. But sale is the one which could be regulated. That's just a thought, and maybe we could discuss in debate.
Okay, Mohini, this though you have given answer, but somebody asked whether the contra trade restriction apply to trade made by promoters individually or on the entire promoter group.
Promoter and promoter group are not a relation in the PIT. PIT talks about the person and his immediate relative. So if the promoter group person falls under the immediate relative, and immediate relative, I again explain that the person, either he is financially dependent on you or takes your help in trading decision, then only that person is associated with you. So if that person is associated with you, definitely it should be all the provisions, including the contract rate, need to be. Otherwise, for entire promoter group, no.
So me and Savitri are the promoter of the company. We are not related. So if she's selling, I can do contra trade. Okay.
If you are in the promoter group and you are not related, you are not immediate relative, and you have not declared it to company, then.
Okay.
Absolutely, because you may be two separate set of persons and you're not acting in concert also. I mean, of course, that's a different concept altogether. Yeah.
Okay. If in normal course of business, shares given as security, and when in the event of non-payment, if such shares are sold, would it be amount to contra trade? Narayan.
Yeah, if it is within 6 months, we said it would tantamount to contra trade. But if it is conditions beyond the designated person, as we said, the only way right now, since is to go to the compliance officer and seek exemption from the strict, provisions of contra. That's the only way.
So, friends, 77 questions came today, and 60 questions we received. We will compile all the questions and the answer which you have given, send it to SEBI. So when they will come out with contra trade FAQ, it will help to them, and they can understand that where is the issue, where is the confusion, so they can do. Now we have given answer. I will request Sundareshan sir now. Just
absolutely.
His concluding remark, because we were eagerly waiting for his view.
Concluding, absolutely.
Yeah. And Sundareshan sir has told me that Naveen should give answer of all the questions because he will always promote juniors. So there's a great part on his question. Yeah, Sundareshan sir.
You're on mute. Mr. Sundareshan is on mute.
Yes, please.
Yeah, it's okay now.
So waiting for your concluding remarks, sir.
Concluding remarks.
No.
Yeah, we are waiting for your concluding remarks, sir.
I think I have to only, I don't know how many more thanks I have to thank to Mr. Pawan and I know Mohini for taking the trouble of organizing this, and of course to Mr. Narayan Shankar as well as to Savitri for taking that time from that busy schedule. I know how in corporates time is so precious, but for this type of educative purpose, people are coming forward and sharing that. And I hope whatever the questions which are being put and the replies are being given will go a long way in making the people understand. And as Naveen has been telling from time to time that whatever feedback we have received, we will try to incorporate it in the FAQ, because SEBI also nowadays works like a corporate. We also have our KRAs. This KRA has to be applied actually by February 28th. But then, we can take a leeway for about a week or so, and definitely at any cost before this financial year, it has to be put on the website. So we will definitely take this feedback, and I will request Mogini to compile it and share it as early as possible, so that we will officially take it on record and then put it on the website for the benefit of one and all. And Mr. Pawan, once again, thank you for this wonderful opportunity. And it's really a good exercise I feel doing, so that the regulator also takes into account the broad market view, because going and asking each person will be a big challenge. But in this type of collective, discussion takes place, the general consensus view comes out, and that will be better for everyone to implement. With this, I thank for giving me this opportunity, and also Naveen from my side for taking much of the load from me, because so many other things happen, and we have we always have a fortnightly surveillance meeting, so I was busy with that. And I have to thank Naveen also for taking the load from me for that. Thank you, sir. Thank you all.
Thank you. Thank you very much.
Thank you, sir.
Thank you. And Narayan, Savitri, and Naveen, and Mohini. No doubt, everybody has put in his efforts, and we have come out, because that's a main part. Actually, Savitri and Narayan and Mohini, you are doing CSR.
All right.
CSR in a different way. They are giving money, but you are doing CSR by doing and sharing a knowledge and experience. And you can, today we had more than 550 registration, and 370 people joined today. And we received 78 plus 60 questions. So you can understand the interest and the way people have asked. So I'm assuring all of you, we have tried to give answer of all the questions, but in case few questions are not answered, you can write to us immediately that this question is not answered, and we will give you a reply. One question we deliberately left because for a multiple issues, and it was supposed to take too much time, so that's why that we will give separate answer. So sir, we assure you, Monday we will send you all the questions and their answer which the panelist has given. So you can keep, and all questions can give an indication to you, though some answer we are also not clear, you as a regulator can plan. So you can understand that where the issue and where the points, so you can cover up in your FAQ. I hope that this will helpful. So thank you, Savitri and Narayan Shankar and Mohini, to give a CSR to the this way, and Naveen and Narayan and Sundarshan sir, who always encourage. And I think, sir, on openly I'm telling you, this should be the approach of regulator. You are bringing out something, so before bringing out, you want to take the view from public, take their issues, and then you are coming out the finality. Otherwise, what is happening? We are coming out with FAQ on the basis of various questions and various things, and then public is asking again and again that this is not answered, this is not answered, what is the things. So this is a good exercise, and I think this is a very nice which we have done. So thank you very much. Thank you. So friends, our journey of knowledge sharing will continue. As you are aware that first Friday of every month, we are having a company law, security law, and solvency law recap of recent regulatory and legal updates. So next, the first Friday of the next this coming month, we will do this. So whatever happening in the last month, so this month, any new thing is coming that we are discussing and we are telling. So here SEBI has come out 2-3 new concept paper